In 1955, there was more at stake than a seat on the bus. At stake was constitutional rights of equal justice and due process, the right to a seat at the table to participate in social, political, and economic affairs as citizens and as elected officials. More Than a Bus Ride is a story of that struggle. Narrator Richard Porter Jr., a Mississippi civil rights veteran, begins the More Than a Bus Ride story with an early citizenship challenge in the U.S. Supreme Court in 1857 that culminated in Montgomery, Alabama, November 13, 1956.
Congress granted citizenship to Africans living in free states and territories under the terms of the Missouri Compromise. Dred Scott applied for citizenship in Missouri. He was turned down by local and state courts. He appealed to the U.S. Supreme Court in 1857. The majority of the judges, slaveholders themselves, ruled that Scott, and indeed no one of African descent, could be citizens. Blacks had no rights white men had to respect. The decision invalidated the Missouri Compromise. It was the first time that the court had failed to defer to congressional authority. The ruling of the court hastened the Civil War of 1861. After the war, Congress nullified the Dred Scott decision with the passage of the Civil Rights Act of 1866 and the 14th Amendment to the Constitution in 1868. But the court, still dominated by moneyed and slaveholding interests, continued to disregard constitutional and congressional authority. One of its most damaging rulings with widespread impact was the railcar case out of New Orleans, Louisiana in 1896. Brian K. Fair explains the Plessy v. Ferguson ruling and its impact on the American scene.
Homer Plessy, who described himself as 7/8 Caucasian and 1/8 African American, 1/8 colored, said he was entitled to sit, that he was white enough to sit in the white car, that he was white enough to enjoy the reputation of a white person. Plessy was a test case. The local activist community in New Orleans decided to challenge the railway car segregation ordinance. But there, the Supreme Court adopted a principle of separate but equal. Plessy declared that it was permissible for the government to separate persons in railway cars and common carriers by race, as long as the separate facilities were equal. And so in 1896, in the Plessy case, the Supreme Court announced this doctrine, contrary to the Constitution itself, that no state should deny any person equal protection of the law, that the law should be the same for the white and the same for the colored. The Supreme Court went in a different direction and adopted this principle of separate but equal. And out of Plessy would grow this enormous system of segregation laws, not just in Montgomery, but throughout Alabama, throughout the 13 southern states that had seceded from the Union.
It was in this Jim Crow setting in 1955 that black citizens began to push for change. They held a candidates forum at the Black Benmore Hotel to hear candidates' views on their list of demands. Bus seating was their number one issue.
The black leadership, led by Edgar D. Nixon, who was a black labor leader and the head of the Montgomery local of the Brotherhood of Sleeping Car Porters, had prepared a questionnaire which they asked all of the candidates to answer. And number one on the list of questionnaire, on the list of questions on the questionnaire, was where each candidate stood on bus seating. The black leadership wanted the Montgomery Bus Company to adopt the same seating pattern that it was using in Mobile, which is called the Mobile Plan. in the parlance of the time. And that was the proposal of the black leaders at this meeting at the Benmore Hotel.
The slate of candidates supported by blacks lost, and their demands fell on deaf ears. During the campaign, Claudette Colvin, the first of 3 women, was arrested for refusing to give up her seat on the bus.
That day, March the 2nd, I and some of my classmates boarded the Dexter Avenue, boarded the Highland Garden bus on the corner of Dexter Avenue, right across the street from Reverend King's church. And the bus proceeded down Dexter Avenue, and about 2 stops, more white passengers got on the bus, which outnumbered more black passengers. But the bus motorman looked in the rearview mirror and demanded 4 seats. 3 of the students got up, but I still remained seated because I knew I wasn't violating the Plessy versus Ferguson law. And the bus motorman saw that I was still sitting there, and this white woman refused to sit in the opposite seat opposite me, because at that time, as it said, a white person wasn't supposed to sit in the opposite seat across from a black person. They were supposed to sit in the front of a black person. Now, she had a seat there, but she would not sit, and she was standing. And a squad car came beside the bus, and 2 policemen came on the bus without any diplomacy, saw the white woman standing up, and I was sitting. She was standing up and refused to sit. And he said, "Gayle, why are you sitting there?" I was more defiant then. The policeman dragged me off, manhandled me because I refused to walk, and put me in the police car. And then they handcuffed me through the window, and they took me to City Hall, booked me, and then so they put me back in the car, the squad car, and took me to jail. Reverend H.H. Johnson and my mother came and bailed me out. And after then, my parents got Attorney Fred Gray to take my case, and I got support from E.D. Nixon, and also I joined Mrs. Rosa Parks' Youth Council, and the rest is history. My case went to the juvenile court, and I was charged with violating the segregation law and assault and battery and disorderly conduct, and I was put on probation for 1 year.
My incident happened on October the 21st, 1955. I had went to work for a family in the area of Highland Avenue. And on that Friday, I had worked about 2 weeks for this family. And on Friday, they did not pay me, so I returned to their home that Monday morning to get my pay. I went there, knocked on the door, and no one answered. So you can imagine how I felt, boarding the bus back home with just your fare, didn't get paid, and had no work the whole week. And I got on the bus, sit behind the sign, set colored to the back, and the arrow point white to the front. I was sitting behind that sign when a lady got on the bus, and the white man got up and gave her his seat. And so the white man was standing, so the bus driver asked me to give my seat to the white man. I refused. And so the bus driver drove about, I guess maybe about a couple of blocks. He got off the bus and went to a telephone booth and called the police officers. They arrested me, took me down, booked me, and handcuffed me. That's the bad part about it. I just feel that, you just done something very criminal and being persecuted. So I called my dad, and my dad came and paid the fine and got me out.
On December 1st, 1955, Mrs. Rosa Parks was arrested under virtually the same circumstances as Colvin and Smith. She refused to give up her seat to a white rider. The news of the arrest and the lingering anger over the Colvin incident sparked universal outrage in the black community. Mrs. Parks was well aware of the Colvin incident. She knew Nixon was planning a merchant boycott in December to force the city to accept the Mobile seating plan. She also knew that Attorney Gray wanted to challenge the segregation laws in court. Mrs. Parks, a veteran civil rights activist, had to have known that she might be arrested for disobeying the segregation orders on the bus. And if arrested, she knew it could lend support to the plans of Nixon and Gray. She did not know that Mrs. Robinson was going to call for a boycott, and she was not a plant of the NAACP. Her arrest and the subsequent boycott united leaders formerly divided in the black community.
It was at that point that Nixon, after he had bailed Rosa Parks out of jail that night, began calling other black leaders in town and suggesting a strike. And it's perfectly understandable that Edgar D. Nixon, as a labor leader, from his point of view, the way in which you get the powerful to pay attention to you is a strike. He called Fred Gray, who was one of the two black lawyers in town, and Fred Gray called Joanne Robinson, who was a professor of English at Alabama State University and was the president of the Women's Political Council, a black women's voter organization. And she, on her own motion then, went to Alabama State University and on the mimeograph machine at Alabama State University printed up a series of flyers. And she and the members of the Women's Political Council distributed them all over the city, calling a bus boycott. So by the time the black leadership actually met, these flyers had actually already even called the bus boycott. But it's probable that it would not have been as successful as it was if the meeting at which took place in the basement of the Dexter Avenue Baptist Church had not led to an agreement by all of the black ministers and other local black leaders of various organizations to support this bus boycott. But they did agree, and the following Monday, which was the day that Rosa Parks was brought to trial in Recorder's Court, blacks universally stayed off the bus.
Rosa Parks galvanized, became the symbol of that social protest. And I think it's very important for us to understand, and we were talking earlier about the idea of women. I think the word that doesn't come up often enough is sacrifice. That the importance of the Montgomery Bus Boycott is not so much that it was a boycott, but that it endured for 381 days. That people sacrificed. And we're talking about that was when most people got around. A lot of people didn't have cars. So they actually used the buses for getting to work, for doing their shopping, going from place to place. It was a means of getting around. So people would actually sacrifice, their being late for a job, or possibly losing the job. The idea of, I can't get as much from the grocery store as I might get. And you also realize that town wasn't as big as it is now. By the same token, that a people, would sacrifice and then lost their jobs. Many lost their jobs and had to scrounge and do all kinds of things, but still stayed firm on the course. But I think the thing that's important is that they endured, that they endured. So you begin to look at the Rosa Parks. She's a symbol of galvanizing people to make that sacrifice.
Leaders of black organizations met at the Mount Zion AME Church. They formed the Montgomery Improvement Association to conduct the boycott, wrote a resolution of demands, and chose Dr. Martin Luther King in his absence as spokesperson. Later that evening at the Holt Street Baptist Church mass meeting, the resolution was presented and approved by the community. It authorized MIA leaders to meet with city and bus officials on December 8th to present their demand.
The bus boycott leaders themselves were not really interested in advancing litigation against the city. Before there was any kind of court case, before there was any kind of affidavit, before there was any kind of legal measures taken against the city, the MIA leadership asked the city in calm terms for the most conciliatory things that you could actually ask for. 3 of them in particular. We want the seating done on a first-come, first-served basis. We want our riders to be treated courteously, and we want black drivers.
Changing the system of segregated seating so that they would still be segregated, but it would be less harsh on the passengers. So it was such a minor change in the present system that the NAACP first told us, we are not going to give you any kind of support because you're not fighting segregation. You're admitting to the local authorities that you're willing to maintain segregation. And it was not until the suit was filed that the NAACP said, now that you're fighting segregation per se, we're willing to work with you.
I was thoroughly convinced early on that the way that we were going to solve the problems on the buses and everything else in Montgomery so far as segregation was concerned was to file lawsuits. We'd have to do other things, but the bottom line is that Montgomery was not going to voluntarily end segregation. Plus, they couldn't voluntarily end it. You had state statutes requiring it. You had city ordinances requiring it. Plus, there was no real desire on the part of the political majority in Montgomery to do it. But I also realized that many of the people who were there were people who had ties with the white community one way or the other. They had been in Montgomery a lot longer than I had been in Montgomery. And most, if not every African American there had some white person that they were probably pretty close to or friends of, or they worked for. So you may have had some persons who had some apprehension about filing a lawsuit, but I never had any such apprehensions because I had been preparing ever since Claudette Carvin's situation to get ready to file the suit that I ultimately filed.
This was new territory for all of us. None of us had been involved in anything like this. And we had to try to figure out what was going to work and what was going to be fruitless. And I think wisely the calmer heads said, wait a minute, if we do nothing but boycott, we may end up with no real gains, and we have to attack the basic underlying fact of segregation.
While the community was discussing filing the lawsuit, Montgomery Improvement Association attorneys Fred Gray and Charles Langford, assisted by Clifford Durr and others, were busy preparing the suit.
So I had only been practicing a few years myself then. I started out in '53, so you can see that was just a few years before all of this happened. And my partner, Fred Gray, was about just a little younger than me. So we were relatively both young attorneys that need help. So the state of Alabama really had very few black attorneys in the state. So all of them work with us in this matter. And especially I can think of Arthur Shores from Birmingham and Peter Hall, Isaiah Billingsley. Plus we had them from all over the country, and then the law school at Howard University. We gave what we would call dry runs there of actually going through the trial with them. And then the Legal Defense Fund of the NACP, which had at that time some of the top lawyers in the country in this area, black or white.
In January 1956, Montgomery Mayor Tacky Gayle announced a Get Tough campaign. He refused to continue negotiations. The original goals of the boycott had failed. The leadership had two choices: give in with no changes or file the lawsuit to end segregated seating. At a January board meeting, Dr. King announced that a lawsuit had been prepared and they needed plaintiffs. No one on the MIA board volunteered.
One of the problems, of course, is that if you file a suit, you have to have plaintiffs. In other words, you have to have people who will declare to the court that they have been wronged by the law and that they're asking for that law to be changed, which meant that people had to sign on the dotted line, I will charge the court with the responsibility of changing an unjust law, which means I'm ready to say that I'm opposed to the law, I'm opposed to the system we've been living under. And that meant exposing themselves to all kinds of repercussions. People could get killed even just by filing suit against a segregation law. So those women who originally signed as plaintiffs in this case were very brave women. And one of them, as you know, dropped out of the case, and she had enormous pressure put on her to drop out of the case and finally felt she had to do it.
Mr. Nixon opposed using Colvin and Smith as test plaintiffs. He reported to the MIA board that Colvin was pregnant at the time of her arrest and that Smith's father was a drunk, and therefore they would not make a favorable impression on white judges. Colvin was not pregnant in March, and Mr. Smith was a retired disabled laborer. Unfortunately, writers and historians have reported Mr. Nixon's account of events without verifying them for truth and accuracy.
Claudette I had already represented, so I had immediate contact with her, and I knew that she wanted to do that because she was not happy, and her parents were not happy with what ultimately happened in her case. So this was really a redeeming sort of thing in her situation. Mary Louise Smith, we did not know about her until after Mrs. Parks had been arrested, and when she immediately became known, and we found out and was able to verify what had happened to her, she would also have made a very good plaintiff. Because Mary Louise was young, and I believe she was a minor at the time also, if I recall. So we really had two minors where suits were being filed by the parents on their behalf. And then we had two kind of senior adults in terms of Mrs. McDonald and Mrs. Reese. And Mrs. Browder was kind of the middle-aged person. And the final analysis on all of the suits that I filed, and I guess most other lawyers filed, particularly where it's a class action suit, the lawyer usually determines who will be the lead plaintiff. And I made that determination and decided to use Mrs. Browder. But it didn't mean that her role was any greater or less than the last person whose name appeared as a plaintiff in the lawsuit. They were all very important.
But I think really important are those people that came and said, I'm willing to go to court for it. Now, even though Rosa Parks ended up moving from here because she had, death threats and all that kind of thing, These other people stayed here, but they'd had death threats also, because they went up against the law, to say, I'm going to go against the establishment.
Mrs. Browder was a 33-year-old mother of 5 children, a businesswoman, a nurse midwife, and a student at Alabama State University. In April of 1955, she was forced to give up her seat to a white rider. Asked why she agreed to become a plaintiff, she said, "I wanted better treatment, and I knew if I cooperated with my color, I would finally get it." She and her family received constant death threats, and she was denied a teaching position in Montgomery Public Schools because of her stand. Mrs. Sue McDonald, affectionately called Mama Sue, was a businesswoman, educator, and activist. On October 1955, she was forced to give up her seat to a white rider. She supported the boycott and agreed to become a plaintiff to help end mistreatment on buses. Mrs. McDonald was 77 years old at the time of the trial.
When Attorney Fred Gray contacted my parents, and my parents agreed for me to be one of the plaintiffs in Browder versus Gayle, I agreed. I said, yes, I'm ready to testify. I want to testify and let the world and expose this Jim Crow law and let everybody know how we've been mistreated.
My dad was crippled, and he worked 2 jobs to support 6 of us. And he sent all of us to a private school. And he knew that I didn't do anything wrong. He was standing by me for what I done. And he did sign for me to be a plaintiff in the lawsuit.
On January 30th, Dr. King's home was bombed. The MIA then authorized Attorney Gray to file the class action lawsuit, Browder versus Gayle.
Day before I filed the suit, I told them that we were going to file the suit. And I also told them that they'd be getting phone calls and harassing calls and everything else because their names will be the ones on the complaint. It's not going to be Dr. King. It's not going to be Mrs. Parks. They are going to be the ones, and they're going to have to be able to withstand the heat.
As you had the mayor and the chief of police both being members of the White Citizens Council. And for you to go up and say that I am going to go and put a suit against you, I think that's quite brazen.
This was a direct assault. An assault on segregation is an assault on the white power structure. Not just in Montgomery, but wherever it exists. So to the extent that it exists in South Africa, to the extent that it exists in northern states, wherever it exists, this is a direct assault on that. This is to say, these relations are not normal, they are unfair, they are inconsistent with constitutional doctrine, with the American creed of equality, of equality for all. This is a challenge and assault to all of that.
On May 11th, a 3-judge panel, including Senior Judge Richard Reeves, Frank M. Johnson, and Seaborn Lynn, heard the Browder versus Gayle case. On June 5th, 1956, the judges, by a 2-to-1 majority decision, issued an opinion that segregated seating on buses violated the equality provision of the 14th Amendment and federal civil rights statutes. On June 19, 1956, they wrote the order to end the practice of segregated seating, but issued an injunction until appeals by all parties were heard. On November 13th, the U.S. Supreme Court unanimously upheld the lower court ruling. On December 20th, Montgomery officials received the order from the court, and on December 21st, blacks returned to the buses on a non-segregated basis.
guess you've heard the good news about me breaking down the segregation on the buses. I'm getting so many compliments on the stand I've taken when others back down afraid of their jobs and being dynamited in their home. Sam slept in the front room with his gun and pistols, laid waiting night after night. The man that was throwing the bombs got blowed up himself. Now the whites have organized a KKK after the Supreme Court decision, thinking they would stop the mass meetings the Negro advertised. No KKK showed up at our meetings. These are the bravest Negroes I ever saw. Vash, at these meetings, the sweetest singing and praying you ever heard. Child, we are on the ball.
What's the impact of Browder versus Gayle? Now that we see the battle for the rule of law, what is the impact? First of all, it is a given that Browder v. Gayle, not Brown v. Bolt, Browder v. Gayle reversed Plessy versus Ferguson. So in a way, Lynn was right. It had not been reversed prior to this case. I mean, he comes out wrong, but he says they didn't overrule this, and it didn't, because I can read you from the National Center for History in Schools, which has in its materials teaching across this country, technically it was this case, Browder v. Gayle, and not Brown, that overturned Plessy versus Ferguson. So if anybody asks you what put the nail in separate but equal, it is this case out of Montgomery, Alabama. And I think this case also began the Fifth Circuit as a major foundation stone, as a national leader in civil rights. For those of you who don't know, everybody referred to them as the Four: Elbert Tuttle, John Brown, John Minor Wisdom, and Richard Reeves. And their workmen were Frank Johnson and Shelley Wright out of New Orleans. Would the career of Martin Luther King and would the boycott have been the success they were without this case? It is important to appreciate that without the suit and the eventual support of the United States Supreme Court, and the boycott may well have ended without attaining any of its expressed goals, a result that may have been cruelly discouraging.
Those of us who live today stand on the shoulders of these young heroes and heroines who gave so much, who risked so much, who demonstrated so much courage and so much bravery. I could not be at the University of Alabama today as a professor of law had it not been for cases like Brown, cases like Browder versus Gayle. I couldn't enjoy the kinds of liberties and freedoms that I enjoy today if it hadn't been for a case like Browder versus Gayle. I couldn't enjoy the public parks, the public swimming holes, the municipal facilities, had it not been for a case like Browder versus Gayle. And it's an important case. It's a case that more people should know about. We should know about the women, about their courage, about their lives, about the transformation of a city like Montgomery through the bravery of these people.
One of the things that grew out of that movement was the realization over a period of time that oppression was not only white against black, but we soon learned that males had been oppressing females for many years, and many of us were simply unaware of it. We learned that people with handicapping conditions were sometimes being oppressed. We learned that poverty is a form of oppression, and that there are hundreds of thousands of people, millions of people in this country who simply are never going to make it because they will never have enough resources to have a decent life. We have learned that there are oppressions in terms of sexual orientation. In fact, we like to joke and say that God had a hard time teaching us, so he had to use show and tell with us. He gave us 2 grandchildren who were handicapped. He gave us a son who was gay and who later died with AIDS. And so we experienced some of this oppression for ourselves within our own family. We have a daughter who is married to a Muslim man. And we see how in this country today, being Muslim is a dangerous thing. There are so many forms of oppression all around us. And we simply have to be on our guard to identify the kinds of oppression that are being practiced and to begin to deal with those things. And we tell people all over the country that they should not wait until a Montgomery movement comes along, or a Birmingham movement, or a Selma movement, but that they should be involved where they are. As Booker T. Washington used to say, you have to let down your buckets where you are. And people can be aware of subtle oppressions around them, hearing people use bad language about a person of another race, or another sexual orientation, or another religion, or whatever it may be. They can simply say, that offends me about them.
Well, I would want to add that this whole idea of nonviolence in taking care of these problems is the way we've got to go. We can't just keep having wars all over the world and trying to retaliate when something happens. We've got to find peaceful ways of taking care of our problems.
If the lives and work of these women, Mrs. Parks, Miss Carving, Miss Ware, and others, means anything, it means the struggle continues, and we must devote our time and our effort toward finishing that task. We face a real challenge as to whether the gains we have obtained will continue or will be lost. And more remains to be achieved. If we lose, it will mean that others who have given their lives in the cause of human and civil rights have died in vain. If we lose, the nation loses. One, we need to recognize that the question of racism in this country is still a problem, and there are still too many decisions that's being made based on race. Secondly, racism is not going to go away. It started in Jamestown when the first slaves landed, and it is not going to go away by itself. We're going to have to come up with a plan. And then after we come up with the plan, we're going to have to execute it. And I submit to you that one of those problems is the economic discrimination which still exists in this country. We have seen changes in the United States Supreme Court, which for over a half century had been a pioneer in the rights of minorities and women. And that court now is on the verge of reversing itself on some of these most important principles. And we are not quite sure right now where we're going. We have witnessed the resurgence of hate groups, and many of the old wrongs remain unsolved. The struggle has not ended. Discrimination in the United States has not ended. We do not have a level playing field, and there's no such thing as a race-neutral society in America. This case is based on law or its journey through the courts. But the case, while it was necessary to litigate these issues through the courts, it was really about people, and it was about a cause. It simply took the law to further the cause and empower the people. The law prevailed, and when the law prevails, the people prevails. There remains much work to be done, and there are others who are capable of doing the job. I challenge each of you to be one of those persons committed to finish the job. Claudette Carvin, Mary Louise Smith, Rosa Parks said no, and remained seated on city buses.
But they stood tall in their individual fights against injustice, unjustified racism. They said no and refused to give up their seats on city buses in Montgomery, Alabama in 1955. But they willingly sacrificed their quiet dignity for the greater good. Claudette Carbon, Mary Louise Smith, Rosa Parks said no one day because they were tired, not from a long day's work or school, but tired from a long life of injustice. They rested their minds and conscience by knowing that they were not breaking the law, but demanding the law. In order for the rule of law to triumph behind every act is a human being. They said no, and the rest is history.
The legal victory took the law away from the segregationists and forced them to go outside the law to maintain power. The efforts of the plaintiffs helped to destroy the aura of invincibility of white supremacy and set the table for passage of the Civil Rights Act, the Voting Rights Act, the Public Accommodations Act, Title IX, and other significant legislation. The actions of the plaintiffs forced the states to recognize 14th Amendment constitutional rights of equal justice and due process for all citizens, regardless of race, religion, color, creed, sex, sexual preference, age, or national origin. The Browder versus Gayle decision reestablished the ideal that the government cannot create different classes of citizenship.
So thankful today, not realize that this was going to be such an impact on so many people. And I am very thankful and grateful that I were arrested.
Some of our young children, especially African American, rolling or wallowing around, as my grandmother would say, in defeatism. They don't know all the struggle and all the suffering and all the sacrifice that the older generation have made to make these things, these few laws that's on the book now possible. And to the young generation, I say, if you fall, don't stay down. Get up and go again. Start all over again. And if you see some injustice, expose it, and don't be afraid to expose it. Stand up if you have to stand alone, and God will help you.